Hello, I am Ibukunoluwa, a graduate intern at Harlem. Today I'll be talking on the obligations and liabilities of a doctor. A doctor-patient relationship is regarded as a fiduciary relationship in which mutual trust and confidence is essential. A doctor-patient relationship is formed when a doctor affirmatively acts in the patient's interest or agrees to do so. When a doctor-patient relationship is formed, there are certain rights a patient has in law. Such rights include rights to treatment, rights to know the available treatment options, rights to keep a record or a copy of his medical record, rights to know the seriousness of his or her condition, and many others. Once a doctor consensually enters into such relationship, that is a doctor-patient relationship, a legal contract is formed in which a doctor holds certain obligations to the patient. Duties of a doctor include duty to provide adequate care and treatment, duty to keep the records of the patient confidential, duty to tell the patient the seriousness of his or her medical condition, treatment to tell the patient the diagnosis and prognosis of his or her condition, duty to tell the patient the available treatment options, duty to provide adequate follow-up within reasonable time, among many others. There are various rules by which doctors are bound, which are stipulated into statute and code of professional conduct. In this light, a doctor could incur liabilities. They include criminal liabilities, civil liabilities, as well as ethical liabilities. A doctor could be liable under civil law for false imprisonment, negligence, among many others. Also, the doctor could be criminally liable for criminal negligence, for manslaughter, among many others. In the case of R against Akerele, a doctor administered a dose of Sobita on the patient with a view to curing the patient's disease of yours. The treatment that was administered was said to have caused the patient's death. The doctor was arraigned for manslaughter. In cases like this, there are relevant laws that are applicable. They include the Criminal Code, the Penal Code, the Administration of Criminal Justice Act, among many others. A doctor could also incur ethical liabilities such as gross professional misconduct, breach of duty of care, breach of duty to provide adequate follow-up within reasonable time, among many others. When this happens, the Medical and Dental Practitioners Act and as well as the Code of Professional Conduct will be applicable. The Medical and Dental Practitioners Act in section 15 provides for the establishment of a disciplinary tribunal. In this disciplinary tribunal, erring doctors will be tried and penalties will be given. Section 16 and 17 further provides for offenses and penalties. Penalties include term of imprisonment, fine, suspension, revocation of the medical licenses, among many others. Oftentimes, victims of medical negligence and other medical malpractices do not institute actions against their doctors. This is as a result of low awareness and the cultural norm in which humans attribute every mishap to God's will. As a patient, if you notice any negligence or any other medical malpractices in the course of your treatment, you should say something. You can hold the doctor responsible as well as the management of the hospital. You can sue them at a competent court of law. If you would like to learn more about medical law or any other area of law, you can log into our website on www.harlemsolicitors.com. You could also follow us on our social media platforms: Instagram at Harlem Solicitors, YouTube at Harlem Solicitors, LinkedIn at Harlem Solicitors, or even Twitter at Harlem Solicitors.